Good morning, everyone. I'm Olivia Hollaus for Boca magazine, and welcome to another coffee break with our recurring guest, Marius Ged, managing partner of Ged Lawyers. How are you, Marty?
Good morning, Olivia. Doing really well, thank you. How about yourself?
Same. It's Thursday and it's been a great week. We have been chatting every week on so many important topics, and this week is as important as the other ones. We are chatting about wills, trust, and estate planning. So, Marty, when someone is planning their estate, what are the documents that are important?
So, first of all, in Florida, it's something important to understand. Whether you write a will or not, the state of Florida will give you a will. And what I mean by that is the Florida statutes have what's called an intestacy statute. And if you don't affirmatively write your own will or estate planning documents, you have to follow the state of Florida's statutes, which means you will not have control of your assets, you will not have control of the distribution of your assets, and your kids may not get what you want. So, any estate plan, we recommend for anyone in the state of Florida to have at least these four documents. The first is a will, and I'll explain each independently what they are. The second is a durable power of attorney. The third is a living will. And the fourth is a healthcare surrogate. And just a brief explanation of all these different documents because they're extremely important in anyone's estate plan. First, the will is a written document that has to follow certain formalities. And what I mean by that, Olivia, is it has to be notarized and witnessed by two independent people witnessing the execution of that document. And the will is a document which prescribes or describes how you want your assets to go or to be given to after your demise, meaning who are your beneficiaries. And again, if you don't choose that, the state of Florida will determine the order of your beneficiaries. Secondly, and really these are all equally important, is the durable power of attorney. In Florida, we're allowed to appoint someone else to step in our shoes and act as our agent. And a power of attorney allows someone, for example, to take control of someone else's finance. A lot of times a loved one or a parent gets older and they just don't have the mental faculties or the drive to take care of their own finances. So what we recommend to do is appoint someone to do that. And the way to do that legally is through a power of attorney. The power of attorney is something that's very broad and very dangerous if not given to someone who you trust. You can always revoke the power of attorney, but once you appoint someone as a power of attorney, they have really unfettered access into your financial management and have control of your financial management. So it's a very good thing. And sometimes if in the wrong person's hands, can be a dangerous situation. Thirdly, is what we call the living will. And our state is famous or infamous maybe for the famous case of the Terry Schiavo matter, which was during the during the early 90s when a woman got into a really bad car accident and she was in a coma for many, many years. And her husband wanted to pull the plug. And if you remember, her parents fought this all the way to the Florida Supreme Court first, and then to the United States Supreme Court. And what came from that document is everyone, including you and me, have the right to die with dignity. We have the right to affirmatively tell doctors and medical care providers certain things that we may or may not want to happen at the end stage care of our life. For example, a lot of times older people don't want, they call it a DNR, do not resuscitate, or don't want certain types of medical treatment, and they'd rather die without being poked and prodded. By completing your living will, you actually will affirmatively make those healthcare decisions when you're competent, which is very important, and you'll actually remove that decision from your next of kin or your children, which is sometimes the biggest benefit of completing a living will. You know, we live in a society where medicine is rapidly changing and things are progressing, but sometimes people don't want their children to make that decision. So they can make that decision for themselves during their lifetime. And then finally is a healthcare surrogate. And a healthcare surrogate is similar to a power of attorney, but this is where you appoint someone else, whether it's your spouse, your brother, your sister, whoever you would like to appoint, to be your healthcare surrogate and act on your behalf to make healthcare decisions. So all four of these documents are what we call the necessary basic estate planning documents.
And this might be a very basic question, but can you explain to us what is the difference between a will and a trust?
Great question, Olivia. Everyone gets those confused all the time. A trust is a document that you create during your life and you transfer certain assets to during your life or even after your demise. And that document becomes a living entity. And that document holds title to certain assets like your bank accounts, your brokerage accounts, and your what real estate, any asset that you own, the trust could technically own. The major difference between a trust and a will is that if you plan properly and create what we recommend, which is a revocable living trust, you will be able to avoid the probate process. For example, if you die with a will, all of your assets have to transfer through the probate court and they have to be administered through the probate court. And that sometimes, well, right now at least specifically, is a very time consuming, burdensome, and expensive process. And more importantly, your assets may become subject to creditors' claims, whereas if you die with a revocable trust and your trust is properly funded, that trust does not, those assets do not have to go through probate, and they just remain on course with the normal course of business and don't have to be subject to public notice, to there's privacy issues, there's obviously creditors issues, many different issues, and really many benefits of creating a trust during your life.
You actually just answered my question on probate litigation. I've seen this happen where, after someone passes away, the will gets contested. How do you avoid that from happening?
So because you drafted a will or a trust does not mean it can't be contested. Anyone can contest. And in Florida, there is a lot of times a disinherited beneficiary or a disinherited relative gets upset, quite frankly, and thinks they're entitled to something. One of the best ways to avoid that, because in Florida, there's no requirement for you or me to leave our assets to anyone. It's our choice. So if you have children, and this happens a lot, people, for whatever the reason may be, and just using an example of two children, if someone has two children, if one of the children are very well off, or one of the children maybe has a special need, a healthcare situation, parents don't have to equally divide their assets. They're allowed to divide them however they want. Moreover, they're allowed to give it all to charity if they want. So one of the things that's important is to make sure you have a valid will conforming with the state of Florida requirements. And that also applies to a trust, making sure you're conforming to the valid requirements of forming that trust. But also some of the different things that we do. Sometimes we have clients that are elderly and they're concerned about their children challenging their trust or challenging their estate or their wills. And one of the things that we do is we actually videotape the will. We have them videotape their last intentions. We create a digital record of that. And it's actually really important sometimes after the fact, because if a disinterested child becomes litigious and sues the estate, now there's further proof that this is what we call the testator, their intention. And truly, the law protects that person's intention. You and I are allowed to, again, distribute our assets to whom we want, how we want, and when we want. It is not up to our beneficiaries to drive that bus. So that's something that we can protect in Florida law.
That's amazing that you're using video to do that. So that's really great. And I think a great tool for all of us to keep in mind. Going back to trusts, at what point do you recommend setting up a family trust? Should that be everyone? Should we all be doing that alongside the will and everything else that is part of the documentation?
Sure. There's no best time other than, as we say now, to do these types of things, because a rainy day comes and then something happens and it becomes too late. Often we're called when a loved one or a mother or father is on their deathbed, so to speak, and they are trying to then avoid probate. and they say, hey, Marty, can you come do my mom's will or my mom's trust at this point? And, if they're not competent or they don't have the faculties, quite frankly, it's too late to do that. And we can't do that. The client has to be what we call sui juris, or fully competent to make those decisions. So the benefit of doing a trust early on is when you gather assets and you get married and buy a house and start accumulating assets, it's better to do it early on. And the main reason is because a trust can be modified or amended throughout your lifetime. The document is really expandable with your life, and contractable with your life. So it's something that you can put in place at an early stage, and you can amend as life goes on. And you can always, up until the day you die, change your trust to accommodate your beneficiaries, or to accommodate your wishes and your specific intentions.
Right? Because life happens, things change. How often would you recommend someone reviewing their estate plan?
So generally every 3 years is a good idea. A lot of times there are changes in the law that may affect the trust and how the trust language will apply. Um, you know, Years ago when I first began in practice, the estate tax exemption was $1 million, and then it was a $5 million exemption. Now it's an $11.5 million per person, or $23 million for a married couple. So those federal laws that really affect Florida citizens are important, because in Florida, which is one of the benefits of living here in Florida, as compared to the northern states such as New Jersey or New York, there is no death tax in Florida. So that means you're only subject to federal estate tax. And the law does change from time to time, and you want to be abreast of those situations and those changes and modify your trust documents accordingly.
And, any final tips that you would have for our viewers, regarding this topic?
I think you kind of hit it earlier. It's do these things early on, because when that situation occurs, whether it's a tragedy or a sudden incapacity or something happens to a loved one, it's just too late. And really, why wouldn't you want to have your financial affairs and your life affairs in place now, when you're fully competent to understand what they are? And it's kind of like an insurance policy. You buy insurance and you hope you never use it. But when you need it, you need it, and you go to that file to look at the coverages that you have. You better have the right stuff. So something that you want to be proactive about, to make sure you set up early on and just maintain them and modify them as necessary.
Yeah, you can't be over organized or over planned, basically. So definitely something that we all need to make sure that we have in place. Marty, I love to end our conversation on something fun, more personal. So what made you want to become an attorney?
Well, everyone has their story, and I'm not going to go into my full story today. Maybe we can expand upon that at later dates. But from a child, I've always wanted to help people. I knew at the age of 10, 11 years old, I wanted to do something to help people. I couldn't stand blood, and we have a lot of doctors in the family, and I had no interest in medicine. And I really have a passion to make sure to help people, and I get excited helping other people accomplish what they want to accomplish. So the law has provided that for me. It's been an amazing profession. I highly recommend it if you have the passion. It is a rewarding profession, and not necessarily financially, but there's really nothing better than having a client who comes to you at the worst time of their life, because we have a saying in the firm, we're like Roto-Rooter. People don't just want to pick up the phone and talk to an attorney. They're calling because the toilet's overflowing. And the toilet, metaphorically, is their lives. So we want to, or I enjoy entering someone's life at that point and truly being able to guide them. And if you were to have a business card of mine, you'll see what it says underneath it. It's attorney and counselor at law. And a lot of times a good lawyer, or in my opinion, the best lawyers, are first counselors, advising their clients how to navigate a difficult situation, advising them the best way out of that situation, and then doing the proper legal work to do that.
That's great. Well, another super informative chat, Marty. Thank you so much for joining us today.
Thank you, Olivia.
And thank you to our viewers. We wish you a wonderful weekend. Enjoy your coffee. And until next time, next Thursday at 11 a.m., have a wonderful day.
Thank you.
Coffee.
There's my coffee cup. I tried to get it in the screen.
I love it. We see it. Enjoy. Cheers. Bye.
Thank you. Bye-bye.